We are continuing our lectures on the conflicts of interest rule, and we're nearing the end of rule 1.7. Finally, we're talking about comments 26 to 28, which is about non-litigation conflicts, and by this we're primarily referring to transactional matters. Conflicts of interest under paragraph A1 and A2 of rule 1.7 arise in contexts other than litigation. So for example, here's some examples, and by the way, I've mentioned this before in other lectures. The MPRE, the people writing questions for the MPRE love to take examples from the comments to the model rules and turn them into multiple choice questions. So I really suggest, as you do your preparation immediately before you take the MPRE, that you review the comments, the model rules and the comments, and kind of pay close attention to any place that it says, for example, or similarly this, and so forth. All right, so conflict questions can arise in estate planning and estate administration. So a lawyer may be called on to prepare wills for several family members, such as husband and wife, and depending on the circumstances, a conflict of interest may be present. In estate administration, the identity of the client may be unclear under the rule of a particular jurisdiction. And now, if you haven't had trusts and estates or wills and estates or something like that, this may be unfamiliar to you. So just real quickly, we have an issue where at common law, someone would hire a lawyer to do their estate planning, to prepare a will or set up a trust or something like that. And let's say the lawyer does a terrible job, right? Commits malpractice, doesn't get the right number of witnesses or something like that. And so the will is actually invalid, right? So the people that were supposed to inherit under that will, the heirs, they're the ones who are actually affected by the lawyer's malpractice, arguably. And it can be even more true when you set up a trust, and then it's clearer that you have these beneficiaries of the trust. And so the problem is that these people, these heirs or beneficiaries of under the will of or under a trust, did not hire the lawyer. They didn't have a contractual relationship with the lawyer, or in my course, we would say there was no privity there, right? They didn't have, so the lawyer didn't have a duty to those people as a client. Well, jurisdictions have split over this, and some jurisdictions have decided that the heirs of a will or beneficiaries of a trust and so forth, because they're the beneficiaries under the lawyer's work, that they should be able to sue the lawyer for malpractice and so forth. And other jurisdictions don't do this. And in my jurisdiction, they say they're not going to, and then sometimes they do anyways. And so you can find cases on each side of this, or pretty big exceptions. But this does mean that sometimes the client is a little unclear. The other scenario to keep in mind is that it's pretty common. Let's say that you have an elderly person who is near death, or maybe they're even in a coma and they're not expected to recover from it. And so their adult relatives, and it could be like the grown children of the person who's dying or near death, could hire a lawyer to try to start putting the affairs in order for them. And so this can really complicate who is the client, right? So if I hire someone, if I'm a middle-aged adult and I have a parent who is elderly and in failing health and maybe not conscious or lucid anymore, or maybe they have dementia or something like that, and I hire them to try to help me sort out the affairs of the estate and do some estate planning and things like that, then it can be a little confusing. And so watch out for that for a lawyer, because you can end up with conflicts of interest. So under one view, the client is a fiduciary. Under another view, the lawyer is the client is the estate or the trust, including its beneficiaries. And this is what I was talking about a moment ago. So is your, do you have a fiduciary relationship to your client, or is the beneficiary or those that you have a duty to the estate or the heirs when it comes to estate planning? And so you should make clear, what they really want you to do is make clear your relationship with the parties involved. Now, whether a conflict is consentable depends on the circumstances. And so let's say, to go back to an earlier illustration I used, let's say you have John, Paul, George, and Ringo come in and they have a band and they want to start a record label and they want you to do the legal work for them. Well, are they all for one and one for all, and it seems like they don't have any differences and they're agreeing to share everything equally? Or as they sit in your office, are they already fighting and screaming at each other and saying, I'll see you in court, and so forth? So if the interests of the people you're representing who have come to you as a group are fundamentally antagonistic, then common representation is not consentable, right? So even if they're like, fine, we'll consent to all using the same lawyer, but we hate each other and we all are going to sue each other eventually, you can't, your consent, getting consent to that conflict of interest won't even be valid. But it generally would be permissible if the clients are generally aligned in interest, even though there is some difference in interest among them. And I'll give an example. Instead of those that are just coming as a group and are going to be aligned on the same side, like we want to form a partnership together, let's say that you represent Greenacre and Redacre, and one of them is selling a piece of commercial real estate, a commercial property, to the other, and they come to you and they say, look, we've actually already agreed on a price, we've generally agreed on the terms, and we just need you to write up the contract, the contract of sale for us, and so forth. So if they've already worked out everything and there's no real, doesn't seem to be anything for you to negotiate, and it doesn't seem like there's a lot of potential for this to fall apart, then you're still going to need to ask for consent. I explain to them, so I do have a conflict, and in theory, it's always better for you, everybody, to have their own lawyer to protect their own interests. But if you're willing to consent, I can provide representation, and it might be cheaper for them. And right, and so that's the question: is what is their disposition, and how likely is it for this to fall apart? So a lawyer may seek to establish or adjust a relationship between the clients on an amicable and mutually advantageous basis. Here's another example. For example, in helping to organize a business in which two or more clients are entrepreneurs, working out the financial reorganization of an enterprise in which two or more clients have an interest, or arranging a property distribution in the settlement of an estate. And so again, to talk about to use the first example, I think that might be the easiest one for law students to grasp. You have some people that come in and they want to organize a business together, and at least they are going to perceive that they're all on the same side, right? They're coming to you because they want to form a legal relationship with each other in the same company, the same corporation or LLC or partnership or something like that. And overall, you can try to do that, and you can try to help them work through any like remaining points of disagreement and so forth. The lawyer seeks to resolve potentially adverse interests by developing the parties' mutual interests. Otherwise, each party might have to obtain separate representation with the possibility of incurring additional cost, complication, or even litigation. And so a lot of times the parties do have some disagreements and they want you to iron that out. And what this is saying is part of what you're going to do when you have this conflict situation, if you do proceed with the representation and they consent to it, is you are going to help them focus on, now there's a reason you have a common goal, or there's some sort of common good, the mutual benefit if you all agree to work together. And so everybody's going to have to give a little. And that is an okay role for the lawyer to say, look, if you want, there is clearly a mutual benefit if you can all work together and come together and form one entity, let's say. But that does mean that everybody has to give in on a couple of points. And that's not necessarily like a non-consentable conflict. And it could save them cost. And if they all get their own lawyer, it's more costly, and then they're going to think, boy, this is going to be complicated. I mean, the more lawyers we have in the room, the more complicated it is, and the more likely somebody's going to end up suing and so forth. And all of that is, those are valid concerns. And because of that, the clients will often prefer that the lawyer act for all of them. And that concludes this lecture.